My name is Peter Menon. I'm the Head of Legal for TPN Credit Bureau, and tonight I'm going to be discussing with you the Huur Gaat Voor Koop principle, but specifically how to protect your property investment when it comes to this very important principle, your OTPs, as well as your lease agreements. I'm going to run through around about 5 questions. I'm going to contextualize what Huur Gaat Voor Koop is, but also certain protective measures that you can put in place in your OTPs as well as your lease agreements to make sure that your property investment is specifically protected. The first question on our minds is, what is Huur Gaat Voor Koop? Huur Gaat Voor Koop is a common law maxim or principle, and what this loosely means is that the new purchaser of the property takes over the lease agreement of the seller, and the tenant in this lease agreement is specifically protected from third parties or the new purchaser. Loosely translated, what we're saying here is that the new purchaser steps into the shoes of the seller or the previous landlord of the property. Now, this is very important. It works by operation of law, meaning ex lege. It happens automatically. You don't need to sign a new lease agreement or a new lease addendum to change the parties in the lease agreement to the new purchaser from the seller of the property. It actually just happens automatically. So whether or not you know this, it is part and parcel to the sale. It's part and parcel to your lease agreements already. In as much as we're saying that the Huur Gaat Voor Koop principle is sort of a full right that the tenant has on the premises, there are certain conditions that we need to take into consideration and specific exclusions. For example, the rights of a bondholder. Say now, for example, a bank who has a prior bond over the property and rights over that property prior to the lease agreement being entered into. What happens to those rights on the sale of the property, or even if there's a sheriff auction and the bank wants to repossess and sell the property as is? Firstly, the sheriff has the option, yes, the option, to sell the property with the lease agreement in place. First things first. If they cannot sell the property with the lease agreement in place, it's very possible that they can sell the property without that lease agreement being in place, and thus the rights that protected the tenant at that point in time is no longer applicable. One of the most important concepts also is promising vacant occupation. And I know this comes up so often. We get a lot of questions at TPN about promising vacant occupation. You've most probably seen in all your OTPs, there's this thing that you write into the OTP that says, we promise vacant occupation on transfer, or also we promise vacant occupation on a certain date. Now, this is definitely a risk that you need to take into consideration. Remember, even if the Huur Gaat Voor Koop principle is applicable, if you promise vacant occupation on a certain date and the tenant doesn't vacate, the seller of that property can actually be held liable for the legal costs should the new purchaser have to evict that tenant from the premises. Also important, remember, we do have these rules in terms of the Prevention of Illegal Evictions Act that says that the landlord or the person that is in control of the property needs to evict the person. So the new purchaser would actually have to evict, but the seller could be held liable for these legal charges. The second question is, what happens to the terms and conditions in your lease agreement? Now, what the Huur Gaat Voor Koop principle teaches us is that all material terms of the lease agreement transfers to the new purchaser and the tenant. That means that the rental amounts, the period of the lease agreement, including how the rental is supposed to be paid and how the deposit is structured, is specifically applicable to the new purchaser and the tenant. Sureties is another question that comes up. And can sureties be held liable in terms of the lease agreement to the new purchaser of the property? Meaning that if the tenant does not pay rental, can the new purchaser go after the sureties in terms of the lease agreement? This question can be answered in the affirmative, and there's a very specific reason for that. The surety binds himself to the lease agreement and to the responsibilities that the tenant has specifically towards payment. Now, if you only swap out the landlord in this instance to the new purchaser, that surety agreement is still applicable because it binds itself to the lease agreement. Remember, very important, that your mandate agreements don't transfer on sale. It's not mandaat gaat voor koop. It is Huur Gaat Voor Koop. That means that your mandate agreements don't transfer to the new purchaser. Even if you wrote certain terms and conditions in the lease agreement that binds a new purchaser or just the landlord to the mandate conditions, you actually need to sign a new mandate with the new purchaser. And the reason for that is the lease agreement only regulates the relationship between a landlord and the tenant. The mandate agreement regulates the relationship between a landlord and the agent. So remember to sign new mandate agreements. One of the questions that always arise when it comes to Huur Gaat Voor Koop is what happens to the deposit. This is something that needs to be taken into consideration in your offer to purchase document. Remember that the Huur Gaat Voor Koop principle merely makes sure that the new owner steps into the shoes of the previous owner of the property and binds the lease agreement terms to that new owner and tenant. So if the deposit was not transferred to the new purchaser at the date of the transfer of the property, specifically by including clauses in your offer to purchase, that deposit and how that deposit has been kept is only regulated by the lease agreement. What I'm saying here is that if the lease agreement says that the owner or the landlord of the premises needs to repay the deposit back to the tenant at the end of the lease term, even if that deposit is not in the new owner's trust account or isn't even in an account that the new owner can access, the new owner will still have to repay that deposit back to the tenant. So it's definitely something that you need to have a look at if you are either the purchaser of the property or the seller of the property, to make sure that the deposit changes hands on the transfer of the property to the new purchaser, or even including terms that the deposit be paid over to the conveyancing attorney upon transfer. Similarly, once transfer occurs, it is important that the new owner keep the deposit in the same way that the lease agreement stipulates the deposit must be kept. I'm sure you all know this, but in terms of the Rental Housing Act, deposits must be kept at an interest-bearing account at a financial institution, and interest must be paid to the tenant at the same rate that a savings account would have at the financial institution. So as a new owner, definitely some risk involved. Remember to write these into your OTP. Keeping with your deposits. Remember, in terms of your lease agreements, it's very possible that a landlord can have a claim to a deposit, perhaps on arrears for rental or ancillary expenses, or even at the end of the contract when there are damages to a property. There's two conditions that we need to have a look at over here. Before the transfer actually occurs in terms of your offer to purchase, and after the transfer occurs. Remember, the lease agreement stipulates where the deposit must be kept, but at the end of the day, it is still the tenant's deposit. So the previous owner would have a claim on the deposit prior to transfer, but after the transfer occurs, he's got no more claim. So please remember, this must all be stipulated in your offer to purchase documents. When selling properties with existing tenants on property, you need to understand and you need to know your rights to protect your property investment. Now, I promised you right at the beginning of this presentation to give you a few loopholes, not necessarily gray areas, but loopholes when it comes to your lease agreements. If you are a TPN Residential Lease Pack subscriber, remember the TPN Residential Lease Pack gets updated every 2 months to occasion itself to any new changes in legislation or anything that really happens in court or with the common law. So what we've included in the TPN Residential Lease Pack is a exclusionary clause, is a loophole for you to use when it comes to property investment and protecting yourself through your lease. In terms of the Rental Housing Act, Section 45C, it stipulates the landlord's rights against the tenant include his or her right to terminate the lease agreement in respect of the rental housing property on grounds that do not constitute an unfair practice, but is also stipulated in your lease agreement. What we're saying over here is that the landlord has an extra right to terminate a lease agreement if it's not against the unfair practice regulations, and also those conditions must be included in your lease. Let's go back to the start. Remember what we said about the Huur Gaat Voor Koop principle. It binds the new owner to the lease agreement. So it inputs the new owner into the lease agreement and binds him to those terms and conditions of the lease with the tenant. This is merely an extra right of termination that the current owner, the seller on the property, has to terminate the lease agreements prior to the actual end date of the contract under certain conditions. Now, what the TPN Residential Lease Pack says is the landlord may, in his sole and absolute discretion, terminate the lease agreement on 2 months, 2 calendar months notice in the following circumstances. The landlord intends to move back into the premises, or the landlord intends to sell the premises. Now here we need to take a pause. We are saying that the landlord, the current owner, the seller of the property, has an extra right to terminate should he wish to sell the property. This does not affect the Huur Gaat Voor Koop principle, and this is very important because we can't exclude the Huur Gaat Voor Koop principle in our lease agreements. We can't say the Huur Gaat Voor Koop principle does not apply to this contract. But what we can do is use Section 45C of the Rental Housing Act proactively to grant the landlord an extra right of termination at the point in which he intends to sell the property. This does not affect Huur Gaat Voor Koop because if he does not choose to action this, if he does not choose to send out that notice, the Huur Gaat Voor Koop principle will still apply. So the new purchaser will still be bound to the lease agreement and still be bound to the tenant in terms of granting the property to him and giving him the use and occupation of the premises. The seller merely has the right, when he intends to sell the property, when he's marketing the property, should he wish to grant vacant occupation, to give the tenant 2 months notice, terminate the lease agreement so that the property can be transferred with vacant occupation. Protect yourself and know your rights as an owner. This is absolutely vital for your successful property investment.